but I'm glad that you're here. I'm Ian Russ. I'm the chair of the Board of Behavioral Sciences, and I've been thinking for a while because of people who call me and they say, oh my God, you know, the boards are so draconian, you know, you're doing custody evaluations, you don't know what you're going to get slammed with, and so on and so forth. So I thought it would be a good idea to put together a panel to discuss what the issues are, primarily in custody evaluations, although when we get to the responses, we can expand that to issues of mediation, special masters, and so on, to talk about what happens when there are complaints. So this is to deal with the issues of complaints. You can't ask, if you have a particular case that's going on, please don't ask us about it. But if you have other questions or generic questions or hypothetical questions, they're all fair. We have a most distinguished panel going from the far end. The most distinguished panel. We have George Varick, my dear friends. Okay. We have George Varick from the Administrative Office of the Court. And among the things that happens is that people often will call him. He's going to talk about his area in a minute, but people are going to call him and say, well, how do we understand what the rules of the court are in these issues? And that's a large function of the Administrative Office of the Court, to help come up with the court procedures and to define what those procedures are all about. And so he's going to talk about the kinds of inquiries that come into the Administrative Office of the Court. He's also a person who determines, if people want to be custody evaluators, what courses that you've taken that might count towards that. So he understands this. He's been involved in it for a long time. He's also a licensed marriage and family therapist. Then we have Bob Schneider. Judge Schneider just retired from the bench in Los Angeles. He was the supervising judge in the family courts. And Bob is going to talk about the complaints that come to the court and the kinds of things that the court will hear and won't hear, and how the court will respond when it comes to the custody evaluations. Next to Bob, Steve Frankel, who is actually, we're going to save for last. Steve is a defense attorney, and after everybody talks about it, Steve is going to talk about how to keep yourself safe. What are the issues in design and in how you set up your work to keep yourself safe, and if there are allegations, how you might respond to them. And he's also going to talk about the issues of being special master or parent coordinator. Next to Steve, we have Lily Grentz, who is the head of family court services in San Jose, that the state has set up that every family court service in the courts is supposed to have procedures for handling complaints. It's my understanding that some counties do and some counties don't, but San Jose does, and Lily's going to talk about the issues that come to the family court service and in terms of complaints and how they're dealt with in the procedures. Next to Lily is Bob Kahane. Bob is the executive officer of the Board of Psychology. And he will talk about both the number of complaints, the kinds of complaints, how the board handles those complaints, investigates those complaints, and so on. And then next to Bob is Paul Riches, who is the executive officer for the Board of Behavioral Sciences. So he does the same thing, his staff does the same thing for family therapists and clinical social workers when complaints arise. All of that being said, I'm going to start with Bob, who's going to talk. Judge Schneider is going to talk about what the issues are that come to the court, what he thinks the legitimate issues are that come to the court, and how the courts handle them.
Right. For judges, complaints seeking consequences to the evaluators are actually reasonably rare. Mainly the complaints and the way we get them is about the content of the recommendation, telling us not to follow the content of the recommendation. So one important note, if you take anything away from what I said, remember that the complaints that we receive in the court typically are not complaints about you. You really aren't an advocate. You're presenting a report, you're presenting a recommendation, But don't present it as an advocate. These are facts. This is my recommendation. I'm putting them forth as evidence. Be a resource to the court. The less you're an advocate, the stronger your presentation is for a judicial officer. Second thing, as a starting point, it's clear everybody here knows on the panel, everybody in the room, most of these complaints are garbage. But still, we have to have a neutral method of processing them, whether they're garbage or not. It's sort of like the digestive system, and if you think about the end of the digestive system, then you'll have an idea of what most of the complaints are like. So let me start just briefly with the statutory framework. I don't want to step on somebody else's toes here, but pursuant to Family Code Section 3110.5, subsection E, a licensed evaluator is subject to discipline by their licensing board. You aren't protected just because you're working for the court. And by context, though not explicitly, that refers to actions taken as part of the evaluation assignment. There are also local rules that I'll refer to the Los Angeles County rules since I'm not familiar with the rules in all 58 counties. Los Angeles County has Rule 1421. It allows a preemptory challenge of an appointed evaluator. That's a form of a complaint. That has to be done within 5 days. So if you're appointed not by stipulation, but the court appoints you, we have a method for the person to say, I'm going to ding that one. I don't want Ms. Jones. She shouldn't do my evaluation. And they don't have to give any reason. Subsequent complaints made about the evaluator are then the responsibility of the judicial officer making the appointment. Honestly, in 27 years, I never received one of those. And I haven't heard of them, so it's going to be a very rare process. In Los Angeles, we also have a panel of evaluators who have met our minimum standards, not a recommended panel, just saying that they've met our minimum standards. And for that panel, a complaint could knock you off the panel. Those complaints are made to the list administrator, who can remove people from the list based on a complaint after some right to hearing and appeal, a due process. So if there is no peremptory challenge, how do the complaints typically arise? As I've said, most of the time, we won't get a complaint before the report is submitted. So let's look first at complaints received by the judicial officer as to a completed report. And let me tell you what the formal response is first. First, there is no requirement to investigate or act. There's nothing, no statute, no court rule that says I have to do anything if I receive a complaint. Those complaints can be, and most typically, as I previously said, are received at the hearing regarding the weight to be given the report. Don't listen to this report because of blah, blah, blah. There is no duty on the judicial officer to initiate a complaint either locally or with the board. We don't have to do that. Conceivably, we could make a complaint to the board. We could present something to the board. That's the formal response. Now, as a practical matter, complaints are significant. They aren't as insignificant as they appeared. Judicial officers talk about experts and attorneys among themselves, just like you talk about us. Reputation is important to you in terms of your future business, and if you have somebody who's getting a lot of complaints, whether they're acted on or not, it's going to affect the business that you receive, could affect the business you receive. Most of the complaints we get are of bias of one form or another. Most are raised after the fact. Most are clearly sour grapes, and most offer really no facts to support them. My favorite case of a complaint, a guy said the evaluator was biased against me because I'm Hispanic. The wife was also Hispanic, and the evaluator was also Hispanic, but he found this to be an important issue to raise. But, typically what you hear is, I walked in the door and she took an immediate dislike to me. She wouldn't let me tell all the facts. She met with the other side first, and the other side set the agenda, so we spent the whole time asking hostile questions. It was just an attack on me. He wouldn't let me say what I wanted to say. I've talked to other women about my case, and I found out this evaluator always favors men. Or, my favorite, my spouse has a lot of money, he's paid off everyone, including the evaluator, and if you don't believe me, Judge, then obviously he's paid off you too. So those are the typical quality of complaints that we receive. They virtually always go to the weight to be given to the report. At least theoretically, they could go to your standing, your license, and those complaints can, of course, go to your reputation and your likelihood of being appointed. We can conceivably receive complaints prior to report. We now have a recent reported decision. You heard about it yesterday if you were in that session. The Laurenti case, where the complaint was there had been inappropriate contact with one side and additionally an inappropriate comment by the evaluator before the evaluation actually started. The judge in that case heard the complaints. She did investigate. She replaced the evaluator. That was a possible response. There could also be a response that would find that this inadvertent contact would not affect the substance of the report. That person could have been kept on. In the Laurenti case, Judge Steinberg removed him, and then there was some consequence with fees. There are cases where I have ordered the evaluator to comment in their report on a similar allegation. For instance, and these are usually follow-up reports where we've had a report done and I want to supplement 6 months later, and they say, don't appoint Mr. Jones. He's biased to me. Husband says you got mad at him because he was smoking in your office, and that biased your report just because he lit up the cigarette. So I will tell part of my charge to the evaluator, please respond to the complaint that you were biased because of the smoking and let them address it completely. I want them to tell me that in fact it didn't affect them in that fashion. And obviously that person was smoking in somebody's office because they're an idiot, and they confronted the evaluator because not only they were an idiot, they're a jerk, and because they're an idiot and a jerk, they're going to get a report that's against them. All of that falls into the same context. It permeates their entire life, and that's why they're going to be making a complaint to the board against you later on. As a judicial officer, I have never been contacted by any board, never asked any questions, never advised of any discipline about anyone that I've appointed. That's doesn't have to be the case, but that's the historical fact. What if I was contacted? A judicial officer cannot be subpoenaed to comment on their decision. Conceivably, I could be asked to comment as a percipient witness if the evaluator got up from the stand and punched one of the parties in the courtroom. Conceivably someone could call me to testify about that. Obviously, a very unlikely set of circumstances. What about the use of the report itself? I would cite Family Code Section 3111B. The report is confidential and cannot be released to third persons other than a few exceptions which do not include the boards. And starting in 2010, there's a provision for monetary sanctions. When it was originally proposed, it was going to be criminal sanctions for disclosure. And the parties have to get notice of this rule in every case starting in 2010 that you can't release the report. So I believe the report itself cannot simply be shipped up to the board. That's obviously going to happen in some cases. You'll get a pro per person representing themselves who either doesn't know or doesn't care about the rule, and they're going to send it up to the board. I don't know what the board's going to do with it. We'll hear about that. There are two categories of complaints that I see. One is the competence complaint. It was a lousy report. They didn't do well. And the other was a breach of professional responsibilities. And I believe that there's a real difference between the evaluator, told me, if you have sex with me, I'll give you a really good report, versus he gave me the treehouse person test, and I don't think that that's a valid test. I think those are really two different things. Those are both fair game for cross-examination in my courtroom, and that is where I will hear most of the complaints, and I certainly would expect lawyers to present those issues and talk about the deficiencies in the report. But I think there's a big difference between those, the competence breaches and the quality breaches versus the professional responsibility breaches. And however, maybe in some extreme cases, somebody always does terrible reports, that sort of flows up to the board. The competence ones, really, everyone recognizes those should be brought up in the courtroom. It should be left to the judge to make a decision as to weight. The professional responsibility ones really are more the charge of the boards, but there obviously can be some overlap. Is there a need for communication between the boards and the courts? I really don't think so. We have a different standard of analysis in each area. Certain unprofessional contact for the board, such as the release of raw test data, if that is a concern. It might be irrelevant to the court decision, really have nothing to do with the validity of the report or the credibility, and it's just nothing that I'm going to be concerned about, whether it's right or wrong. It's just not going to make a difference in my decision of the case, but it might make a big difference. There are different rights for the evaluator between us. The evaluator is not going to be in my courtroom with an attorney, but they are obviously going to want one when they go up with the board. So my philosophies with the boards are just like with the Department of Children and Family Services. You do your job, I'll do mine. We might have some sorts of overlap over the time, but it's really not necessary. One last point in my last 1 minute I think I have. What might reduce the complaints against evaluators? I think you might like to know that. Number one, I think it's basic, but you never can hear it too much. Treat everybody, even crazy people, with respect. Interesting. Martians told you to do this. Very interesting. Let me just write that down. Don't say, you nuts. Treat them with respect. Don't proposition a party is always a good idea. I would go with that. Don't say bad things. And I see this sometimes in the reports. Don't say bad things as if they're true. People are quoting the other side and saying what the issues are, and they start off by saying, this is not me saying it, it's the other side saying it. But really, the context you put it in, the language that you use, just the careful way you write a report, make sure it's clear that you aren't saying it. And don't say to the other side, you beat this child, right? You can certainly you have to say, wife says that you beat the child. What's your response? But the way you frame things, the way you present things, to let people know that you are a neutral and you will be neutral. You'll make a judgment and assessment, but you're starting off from a neutral position. I would suggest that you give some of your protocols in writing. I'm going to ask you about all the bad things that the other side said about you, because that's a constant complaint. They wouldn't let me talk. All they did was make charges against me. So if you put some of that in writing, here's the way it's going to go. I'm going to hear what you have to say about them, and I'm going to ask them about it. I'm going to hear what they have to say about you. I'm going to ask you about it. That can be helpful. It gives, and tell them why. It gives you a chance to refute what they say. You would want to hear that. So when people know the process and they have a better idea of what it is, so if you do one little sheet of paper, not a big whole long thing, but one little sheet of paper that says some of what's going to be happening, I think that would be helpful. And then finally explain why you didn't contact all 35 of the collateral people that they said. That's another big complaint. He talked to all of her people, but he didn't only talk to 18 of my people. And how is that possible? And that's my 10 minutes.
Okay, so the family gets through the court, and that they're not content, and they know in this particular case that the evaluator came from Family Court Services, so they call Lily and complain. And Lily, can you tell us over in San Jose what goes on?
Happy to. Can you hear me? I get probably 2 or 3 calls a week of someone complaining. Typically what I do is talk with the person about what happened. I try to get them to focus on the process, because many people get that mixed up. I think probably everybody on the panel will note that people really are not clear exactly what the evaluator does in terms of making recommendations only, in terms of interviewing the parties. They believe that the evaluator has some more power than they do. If they want me to investigate, or they want the department to investigate, we require now that they put it in writing. And this has come after many, many years of kind of figuring out how to do this. I mean, we're a relatively young organization, less than 30 years old, and I think we've slowly begun to kind of learn how to handle these things. So what we do in Santa Clara County is require that people actually put it in writing. And there is a handout that I was given to you, which is pretty much an explanation of what the court process is, once again, so that the people can know that there's many levels in which they might want to respond. We then send that form out to them. I will get an address. And we require now a proof of service to the other side. We found over the years that what was happening is the complaint process was being used in the service of trying to manipulate the litigation. And so you would get typically a complaint just before a trial because they wanted this person to feel like, I've got my eye on you, and they want to put some pressure on that person to perhaps change their testimony. Or they want to get a do-over of some kind. They don't like the way things have gone, and they will want me to assign the case to someone else. So the person then submits the complaint, the written complaint. What we do at that point is talk with the evaluator, get a sense of what, we give the letter always to the evaluator. They get a chance to talk about the case from their perspective. We always look at the court file, the FCS file, and we try to get a sense of whether the complaint, whether there's any basis at all. And just as the judge was saying, by and large, the complaints are really not valid. However, there are a few that turn out to have some legitimacy. And so we look for instance, if the person complains that we did not follow our own procedures, didn't follow rules of court requirements, we'll actually check it out, and sometimes it is true they have not. I would say the most frequent kind of failing that our staff does or doesn't do is in the DV assessment. We have a very, very clear protocol about what you do when there's been an allegation of domestic violence, and we really ask our staff to go through a particular list of exploration in this area. And sometimes people, we find, want to, because things are so rushed in family court, they kind of brush over stuff. And they will do things like see people together even though there's been a concern about domestic violence, or they won't do a thorough investigation of allegations. That's probably a frequent procedural problem. CPS, they will charge that we either didn't make a CPS report or we didn't consider a CPS report. And this is very easy to check out because we actually put all of that in our records, and there are notes about it, and we actually have CPS reports that are placed in our file. So that's very easy. Sometimes the complaint will be that the evaluator didn't proceed with the case in a timely manner. We have a 60-day deadline, and it's true. Sometimes that happens, and the person didn't file an extension. So those are pretty easy to deal with. You talk with the evaluator, you make sure it gets done, and you respond in terms of, has this been an ongoing pattern? Is this a one-time thing? And so that we may simply talk with the evaluator, or in some instances where it's happened maybe more frequently and we've really kind of worked with that person, then there may be some written counseling or written unfavorable report, or in some instances we've actually even recommended termination. Not because of that, but the other area has to do with testifying on the stand. Sometimes we look at the transcript and the testimony has been not quite accurate. And so that's a major problem. And we sometimes recommend that a case be done all over again in order to protect the due process of the family, and sometimes we recommend for termination. But again, those are very, very, very rare. We probably see something like 2,600 cases a year, and our complaints, written complaints, are probably something like 15, 16, 17 a year. So the number of complaints is really pretty low compared to all the work that we do. When I look at a complaint, I'm always thinking about, is the public protected? That's one part of it. And then secondly, is the employee protected? Because we require a lot of our employees, and we need to make sure that they get the protections of the employer in some instances. I also am really interested in looking at trends, and so we actually created a database, which I handed out. I put mediator down there, but in our court, everybody does everything. So it's really, mediator is like an HR term rather than what the function is. So they're all evaluators. But what we're looking for there is, we actually did, we tabulated how many men complained, how many fathers complained, and how many mothers complained. And that was very interesting, because everybody has, I think, opinions about whether or not the court or family court services is biased toward a particular gender or against a particular gender. And so the outcome of that was kind of interesting, actually, if you're curious. I did some analysis of written complaints from 2002 on to the present, and 43% of the complaints were from fathers, and 54% of the complaints were from mothers, and I couldn't tell in 3% what the gender was of the complaining party. In written complaints, it was 44% by fathers and 52% by mothers. So I was somewhat reassured that we didn't have a really skewed, direction. We look at trends also in terms of the individual evaluator. In our particular county, we do not, and we're not allowed to have performance evaluations. So there are very few tools that we have to allow an evaluator to kind of look at their own work. And so we don't particularly get alarmed about complaints until they get to the level of where they're like twice the average. And then, we really want that person to take a look at why it is that they're getting so many complaints. So let me think about what else you need to know. Yeah, the timing of the complaint is always interesting. If it happens during the middle of a mediation, we actually don't do anything about it except to have a supervisor join that person in mediation. We're not a recommending county, so it's really sort of a process function rather than being worried that in some way justice isn't going to be happening. We look at whether or not the recommendation just came out and they're unhappy with the outcome, or another one is they just got the bill. So you can kind of see all this stuff, and then and furthermore, because the evaluation was so awful, I want the bill erased. So that's kind of where that's at. Yeah, I think that's pretty much it.
Okay. And you also said this morning that even though you're set up to hear complaints about private evaluations, you actually haven't gotten any.
That part is really interesting. I have gotten no complaint about a private person. And my fantasy is that the attorneys can handle that actually in the courtroom. And that over time, certain people maybe don't get used anymore, but that they either challenge the person's findings because of knowledge that they have that they can present to the court, or they get another expert. So that there are some remedies that I think are available to the private people.
Okay, so George, I'm a frustrated parent. The judge obviously didn't listen to me. I already complained to Family Court Services. They're not listening to me. I'm now calling the Administrative Office of the Courts because it says Administrative Office of the Courts on the door. And I want to know, what can you do for me? That this is just an unfair situation, that the judge didn't listen and they didn't follow rules and they didn't follow protocol. And so I have those issues as a complaining parent. And then also, can you tell us some about the variations around the state about the procedures that happen?
So people are going up the food chain. They're starting locally, and then they go to the state office because they say, well, you're in charge of everybody, so we want to tell you about this. They're exasperated, they're frustrated, and they think we have a club that we can then take and beat the local court over the head with, or somebody, to bring them into line and listen to the complaint. So that's kind of the sense we get, that people are exasperated and they're just reaching out in different directions to try to get some redress for their concern. And so they come to us. It's kind of as if a court customer sent a letter to Chief Justice Ron George to complain about the local judge and expecting him to do something about it, but it doesn't quite work that way. But we do get, whereas Lily said that she may get 2 or 3 complaints a week, at the state office of the courts, we may get 2 or 3 a year. And you asked me how many we got. We don't get a lot of complaints. But in addition to the type of complaints that Judge Schneider mentioned, we get an additional type of complaint that has to do with the credentials of the professional, that perhaps they did not fulfill the required 40 hours of initial training, or that they didn't get their continuing education. They're challenging not necessarily the report. They may be challenging that too, but they're trying to get at the credentials of the person. So we get that type of complaint too, since the Administrative Office of the Court, they see us as the one that set up the rule and also the one that approves the required trainings. So they come to us. Because of this, a small group of us went to visit Paul Riches a year or so ago, and Ian Russ, to have a dialogue to kind of clarify this whole issue of complaints and how can they be dealt with. And here's how we kind of deal with the complaints. We don't want to get triangled in at the Administrative Office of the Court in a local matter. If somebody's complaining about a Los Angeles case, we don't want to end up calling Judge Schneider and saying, did you do this or that? So we actually act as we direct people in different directions. When they bring their complaint to us, we ask them questions. Do you have a hearing coming up? That's the place to go and bring up your concern about what the evaluator recommended. That's the proper venue for you to deal with that. We say, do you have an attorney? Then you should, why are you calling us up? Your attorney should be doing this. So we direct them to their attorney. If it's, again, we can direct them to like Family Court Services and their complaint. We can say, have you followed the local court's complaint process? And they may say, oh no. Well then please contact your local court, find out what their procedure is, and follow that. And usually it does involve doing something in writing, and I think that tests the sincerity and seriousness of it if they have to take that further step as opposed to just calling and talking to somebody. Sometimes maybe talking to somebody verbally dismisses the discontent they have, and that might deal with it too. But when they have to do it in writing, that takes it to another step. So I think that means that they're serious about their complaint. Again, if it's about professional conduct that is apart from the rules of court or from evaluator, like if there's some unprofessional conduct, such as an evaluator meeting the evaluee for lunch or something like that, that they may consider goes against the code, then that's something we might say, well, contact the licensing board. That's something that goes beyond following the court rules or the technical procedures for a child custody evaluation or a mediation. Another step, too, that we might ask at the front end is, have you talked to the evaluator or mediator yourself to, perhaps there's a misunderstanding, or perhaps at that very front level something could be resolved if there is a communication there. So we would advise professionals to be open to and non-defensive. Take the complaint, talk about it, try to take an Aikido approach so you don't get resistant and kind of inflammatory in response, but just listen to the complaint saying, well, let me do my best to explain what I was doing here, or let me listen to you and try to clarify this if possible. So sometimes if things can be dealt with, and in other words, the approach is, what's the easiest and most efficient way of dealing with a complaint? And that's, of course, talking to the person that you have the complaint about. If that's possible, do that. But usually people are past that stage, or they're so angry at the person that they don't even want to talk to the person, or maybe they don't respect that person, or they're not civil, or whatever. But if it could take place there, then that would be the level to deal with it. So we direct people to do that too. So we don't get involved. We kind of direct people to the proper avenue where they can pursue their complaint or their concern. Let me refer you to an interesting article which I just happened to read prior to this workshop. It's on parenting coordination practice. It's in the October 2008 Family Court Review, and it pertains to parenting coordination, but it makes several references to complaints, both about child custody evaluation. It kind of compares the two fields, and there are several references in here to complaints, about a half dozen references, and it also alludes to something that probably the next couple panelists will talk about, that even though there are complaints filed, very few are found to have merit, so even though there are complaints. But it's an excellent presentation about the field of parenting coordination that some of you may find yourself involved in. But it's co-authored by Matt Sullivan and Carl Kirkland, so it's worth looking at. So I think that's about all I wanted to. Let me just look at my notes again and see if there's anything I've left off. Again, we don't want to triangle in. We want to be respectful. We take the same approach that Judge Snyder. We believe in treating everybody as a customer. And once I was in a jury room, and I saw somebody else reading a book that says, a complaint is a gift. A complaint is a gift. That was actually the name of the book. And I think the person reading it was in a customer service department of some company. And sometimes I used to be the coordinator of district mediators in Los Angeles, and I would get complaints, and I would feed them back to the mediator and say, here's what I heard. I don't know what to make of this. I wasn't there. I don't have a videotape of the situation in order to form my own, but here's what the person is saying. One time a complaint was about the mediator being dressed a little bit inappropriately in the mother's eyes, or that the mediator was smiling when they came out of the mediation room with the father as if they were in alignment or something. So I started training mediators, have a poker face when you come out of the room, even if you were smiling inside at a joke or something, or establishing rapport with the one person, don't continue to do that when you come out to get the other person. So there's a lot of fine points that I think the evaluator or mediator can do to present the fact that you're impartial and that you're going to be fair to both. And so we deal with people respectfully, but sometimes they're like mosquitoes and they keep buzzing around, and we have to direct them to the proper place. So anyway, those are the comments that I have.
Okay, thank you. I'm going to pose a question that I don't want answered now, but you can put on your list to respond to, Judge Snyder and Steve. So if somebody calls me after I've completed a report to make a complaint to me, I actually won't sit down with them, because the report, I could be called back to do a further report. The report is over. I could be questioned in court about it, but and maybe you can say whether or not that's a good procedure to do or not. Moving up the food chain, what probably brings most of you here today, we're going to have Bob Kahane from the Board of Psychology talk about so you're going to lose your license, okay? Is that what this is about? So you get the complaint, you're going to lose your license. what do? You get this complaint, and then, it's open. The complaint is open for 3 months, 6 months, a year. What's going on? What's happening? Are you guys doing anything, about this? Why aren't you letting me know so that, I can stop paying my analytic bills on a weekly basis? And are you swiping licenses away from people?
Yeah, I think initially I'll give you some figures which would piggyback on a lot of what Judge Snyder said. All our complaints are investigated, okay, regardless of the initial contact of how bizarre or Martian-like it may be. All complaints are investigated, and they are sent out for expert review through our panel of child custody experts. And we have redone our expert review process and vetted those who had 97 areas of intricate expertise down to where you can only be competent in a much lower number than that. So I feel very good about the child custody reviewers we had now. For instance, number-wise, which would say more than I could prosaically, the fiscal year 2005 and 6, we received 84 complaints.
How many people do you license?
I think with retirees and inactives, 19,482. Probably about 19,000. I just made that sound like I did something. We received 84 complaints. Of those, only 20 were referred to formal investigation. So initially, there was no there to even be sent out. Of course, none are pending now, thank goodness. 76 of the 84 were closed. Only 8 resulted in any type of disciplinary action. So we take a very clear and distinct process to make sure that it doesn't go too much one way or we're insensitive to the actual complaint in the first place. The next year, we only received 48 complaints. Don't know why. Statistically, I'm sure someone could make something out. Of those, only 8 were referred to formal investigation. 42 of the 48 were closed. 3 were disciplined. So you're talking about 7% that year. 2007, 2008, 65 complaints were received. Of those, only 6 were referred to formal investigation. 14 are pending. 35 of the 65 were closed, and only 4 resulted in disciplinary action. Most of the related allegations were complaints, of course, similar to Judge Snyder. The evaluator prepared an unfair or unbiased evaluation. This will continue to years to follow, as some cases have been closed to 2 years, and I am still getting personal emails from the aggrieved parties. And staff sometimes gets 3 to 4 a day from certain people whose places have been closed over a year. I'll talk about a response to that and how to take care of that and what we do. The second bullet point was the evaluator was unprofessional during evaluation. That can encompass many, many things, from presentation to perception to any what they think would be a breach of any type of ethical duty. Once again, the evaluator failed to consider all pertinent information and documentation provided. And just because you get a stack of 100 things doesn't. 98 of them can be totally irrelevant, as we all know. And of course, unfair and biased means the evaluator prepared an inaccurate evaluation. This is in deference more to the facts. The families will write in giving us facts, assuming we have some authority to interpret, understand, or change anything, of course, which is not the board's responsibility. And then, of course, the evaluator had a conflict of interest with other parties, whether real or imagined. What we're finding most people look for in the continuation of the case after it's closed or at any point in the line is they're looking for an expansion of board authority to prevent the miscarriage of justice from their point of view. Now, of course, we're only getting this from one of the parties. The other one is moderately happy. Some of the complaints go into very large areas of exactly what would be on the 730 evaluations, why their parents came over, we're biased towards immigrants, we're biased towards this, and everything that we do deal with in everyday society. And as was stated earlier, you know, everyone could be Hispanic, but then again, you'd be biased towards Hispanics. So the responses, no matter how neutral when you're writing back to these people, there's a few things you can't say, attorney-client privilege, and then there's many things we don't want to say, which would be hurtful to the complainant. Facts that we know where, yes, I could get this gentleman off our backs, but the harm and some of the things that we should not say, I think would far exceed that on a personal and professional basis. So we try to remain neutral and factual in all our responses. You have to be very careful when we do so. Anytime you say, I agree, or anything like that, it tends to, they look for you to become, the board to become their advocate, which we don't do. So I have a very good staff. We have some crafted and template responses, and sometimes someone has to be talked to and discussed. And we've had websites put online, help me get back my son, the Board of Psychology is out of control, and all these other things. And, that we're here, we take the shots for it. But everyone is looking for an expansion of board authority to go over into evaluating the evaluators, outside of the expert review process, taking the intricacies of their specific cases and making it right. And we have a very difficult time. I have some people I've been corresponding with probably once a month now for close to 3 years. Their case is closed. But it's a courtesy and a neutral respect that we give. There's sometimes I could say, well, up until you did this, and this, and this, you would have had the kids. That serves absolutely no purpose. It's hurtful. And my staff and I appreciate everything they do, and we absorb it. It's part of the day. It's part of what we do. But as people don't want government's authority to be expanded, unless of course it's in your case in which you'd like the people you're talking to be able to be a cure-all. So we feel we have a good system. We feel the review of the expert review program has given us some very qualified child custody evaluators. We once again end up with some evaluations not signed by both parties, which the board, we use those, don't we, Dana? Yes, we have used those even on occasion because it came in under the authority of the board and they were working under an aspect as being a psychologist. So, let's see what else we had. Most of the time it's why was the case closed if all this information is absolutely incorrect? Why was this case closed if someone has been demonized or they're having an exorcism? And there are very, 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 very strange things coming out of what we get. But still, the reasonableness of the complaint and the actual process is always taken in a courteous and neutral manner, regardless of the rest of the gobbledygook in the actual missives that we receive. Some, I've gotten 20 to 21 page letters, basically why everybody in the world is like it is and why this person happens to be there. And reading it is difficult at times, but we handle it, and we just have to really craft the response courteously, professionally, and understand, not necessarily empathize. And you can step back and just drop the whole thing, just please do not contact our board again. That's not what we do, and that's not how we do it being in a social science at a doctoral level. So once again, very small percentage, 6 to 7%, ever end in any type of disciplinary action. And after the fact, if it is complained about again, I will go through with my enforcement staff and review the actual process. Sometimes there's something. 99% of the time, everything's been done on an up and above basis. So that's
Two quick questions. Okay. One is, has anybody lost a license? And two is, what's the punishment or what's the consequence?
How nice of you to ask. Okay, here's just a few cases. This was 831/07. The primary violation was gross negligence regarding child custody. Engaged in a dual relationship, took on a role as special master, which I'm sure will be discussed later, while providing therapy despite objections by the 730 evaluator. Failed to show possession of education, training, and experience to related services. License was surrendered. Versus something we would have done if they didn't choose to surrender. Another case, gross negligence, unprofessional conduct, failing to report child abuse. Okay, that's not a good one. Failed to report that 2 minor patients were molesting other children in the house. This was discovered, of course, during the evaluation. Revocation. Unprofessional conduct, negligence, conviction of a crime, and fraud. This is just an overview of a couple. We have a bunch under each category, but I'm just going to give you a few of these. Prepared or submitted a report to the Superior Court without conducting proper psychological evaluation for a party involved. Failed to disclose to the court that the report was not an Evidence Code Section 730 report. 5 years probation. Unprofessional conduct, this is the last one, then I'll shut up, I promise. Unprofessional conduct, breach of confidentiality, gross negligence, repeat negligence, and ethics. Wrote report to court order a child custody case without consent of the patient and without a court order. The sentence in itself is the problem. Involved with numerous court cases without proper training experience in family law forensic practice. Written reports were undated and failed to adequately state whether they were psychotherapy in nature or the reports were evaluation for the court. Once again, the specificity of exactly what and for whom you were preparing, that was 3 years probation. And a lot of this, of course, goes back and forth of what we would like, and we will usually settle on something that's moderately fair unless we decide to pursue it further. So, and that is how we do things at the Board of Psychology.
And then if there is a decision, then when people can go online to verify a license, that decision would be listed there. So if there was a complaint, then that, okay. And but if you decide that there was nothing to ding the person for, then nothing shows on the site. Okay. So now on the Board of Behavioral Sciences, my guess is that there are more people in MFTs and clinical social workers who are in family court service than in private practice. I'm on the private practice side. I did work for family court services for a while, but I'm on the private practice side. But Paul, what's the procedure? What are the issues? How many complaints are getting? How many people are we licensing? What percentage of complaints, and what's the issue?
A lot of what Robert said is going to apply for BBS as well. In the handout, we broke our complaints out into 2 categories. For actual 730 evaluators.
It's in your book on the last page after the procedures for filing a complaint for in San Jose Family Court Services.
In 2007-2008 fiscal year, we received 25 complaints on strictly child custody evaluation, 730 evaluator individuals. We received 3 complaints on mediators in that same period of time. None of those proceeded to disciplinary action. Here's how it's bracketed. Much like everyone else up here has spoken about, the people who complain to us are unhappy about outcome. The nature of that complaint is articulated differently at different times, whether it's bias, whether it was an incomplete evaluation, whether it was they bought everybody off, or they were intimidated by my husband, or all of these sorts of things. But at the end of the day, it boils down to the complaint was lodged because they didn't like the outcome. We do the best we can to make it clear to them that we will take their complaint, we will investigate their complaints. We do that with all complaints. But at the end of the day, we can't change the outcome. That outcome issues need to be taken up with the local courts. That's not something we can do. We can evaluate whether or not the licensee acted in a professional manner. And if we see evidence, clear and convincing evidence of unprofessional conduct, we can proceed against that. But at the end of the day, we can go through all of this, and if there is, we'll happily do so. It's not going to change your outcome. And that ends a great deal right there. The outcome was decided by the judge. You have a chance to challenge the report. There are all the procedural safeguards at the lowest level, and our basic position is on outcome-based disputes, we don't have the power to alter the outcome, and even if we did, those would still be better resolved at the local level, so to speak. You want to resolve the issue as close to the problem as possible. We will do much the same as what Robert described. We receive complaints. We do a review of all complaints. It usually starts with a request for documentation, request for releases from everyone who's involved. A lot of our investigations stop cold because, unsurprisingly, the unhappy party is happy to sign a release, and the happy party isn't. And that pretty much ends a great deal right there. We will frequently get copies of the report because people got their hands on a copy and they send it to us. We're a public protection agency. If somebody gives us evidence, well, we're going to take it, and we'll take a look at it. Whether that has consequences for anybody else down the line because of the nature of confidentiality reports, separate issue. We will review it. Usually our first step when we get this kind of complaint after we wade through what is typically a long, convoluted, and multifaceted complaint. It boils down to we didn't like the outcome, but they get there by a lot of different paths all at the same time. Is to write the licensee a letter. It's the same way we handle any other complaint. Frequently the first thing we're going to do is say, we've received these allegations, please respond to these particular issues, here's the enclosed release, so you can talk to us about this and send us the documentation we've asked for. Frequently that will end it. All of our cases in 07, 08 were closed as non-jurisdictional because they wanted a change in outcome. That's not within our power, that's not within our authority, and there wasn't a basis to act. In my time, we've not had a case that I can recall regarding an evaluator or mediator where an action was taken because of the actual evaluation or mediation. It wasn't a skill question. Sometimes we will discover inappropriate dual relationships. We've made mention of it once before. I'll make mention of it again now. We've received a number of very problematic cases relating to special masters, and particularly prior relationships that special masters brought to the special master role, which are from my point of view, inherently problematic, even under the best of circumstances. And the cases end there. Our processing time to get through a complaint is, on average, about 6 months right now. So folks who complain are, probably going to take a couple months before the first letters go out. It's going to take a couple months after that before things get resolved, and that's on average. Some are faster, some are slower. It depends on circumstance. Depends on cooperation, depends on the availability of releases. Some things close down very quickly. Without consents and no documents, we have no investigation. It's done very quickly. If we get consents and releases, then it can take longer to review the material. It's usually pretty extensive. We do have expert evaluators that we can send cases to when we feel we need to. It's relatively unusual, because after the first investigation, it's pretty clear that this is not something that's within the board's jurisdiction, and it's strictly an outcomes question. Certainly, if we were to get clear and convincing proof of bias, that would be actionable. It's something we could do. But in these situations, the, quote, clear evidence of bias is dissatisfaction with the outcome. It's a very hard thing to prove. It's not something I would expect we're going to prove very often, if at all. And that's the end of it. The best thing we can do, and it doesn't lead to a lot of happy people, is try to explain to them what are their options to get relief. That if they have grievances, where can they go where someone can actually do something about the problem? Like I said, it's usually an outcomes-based, that's usually referenced back to the court, and that's usually an unhappy event because they lost their once already, at least in their mind. The issue of ongoingness. We'll close out a complaint. Once we close the complaint, it's closed. As a matter of policy for the licensees, we're here to know, if asked by anyone other than someone who's a party to the investigation, as a matter of policy, we will not reveal whether there's an investigation, a complaint, or not. So if we get an inquiry from someone, we'll say it's board policy not to comment on the existence or non-existence of any investigation until such time as we take an action on it. So those things, once we get them, they're closed, they're done, they're gone. We don't list them publicly, we don't talk about them. If we can't substantiate it, we don't talk about it. How do you handle them? Some of these people are very unhappy, and understandably so, not only because of the outcomes in their custody situations. Frequently we see our individuals who have had a lot of damage and trauma in their life that led up to the divorce and the custody situation, and they're still suffering from that as much as the custody situation. Our responses are very clean and limited when we close a case. Essentially, what we tell them is the board was unable to find clear and convincing evidence of unprofessional conduct. I can write that letter, my staff can write that letter one of 3 or 4 or 5 different ways, and we stick to it. And in our experience, there's no benefit to engaging on the facts. And once we've conducted our investigation and we've done what we've done, we will politely but consistently repeat to them that whether or not what they allege is true or not, we cannot meet our evidentiary burden. Clear and convincing evidence is a very high burden, and we couldn't find it here, and that's really the end of our discussion. It's not to right the world's wrongs. That's not our role. Our role is to meet our evidentiary burden to pursue a disciplinary action. If we can't do that, our role ends. And that's an unsatisfactory response. You stated gently and politely and firmly, and just decline to get into the specifics, because that's a downward spiral into a place nobody wants to go. And in our experience, individuals will take any utterance of the board to be the vindication for them and proof that the world is wrong them, and take that out and wave it around anybody who will listen. So we're very aware of that and very careful about how we couch our closure letters. With that, I think I'm going to end. And
the setup to defense counsel is a couple of things. First of all, I want to warn you how to read the information here, okay? Because when I first got on the Board of Behavioral Sciences and I saw that there, percentage-wise, the number of people we license, we don't get too many complaints, 1,200 a year or so, usually less. Actionable or investigated maybe 400, actionable maybe 60, 70, something like that. That what I don't want people to do is to say, oh, well, there are no cops around the corner, so I can speed whenever I want to. Okay? So I would, rather than saying, oh, well, I can help be sloppy and I don't have to do good stuff here, my general read on it is that most people are doing a pretty good job making sure you don't have dual relationships, making sure you're not testing if you're not qualified to test, making sure that you're seeing both sides, that you have procedures, you got the forms, you got the contracts, you wait till the court order comes, and things like that. But so, Steve, I now get a letter from the board. I assume you send a letter, don't call me, leave it on my voicemail. So I get a letter from the board that says I'm being investigated because of a court report that I did. What do I do? I want you to start there and then work backwards on how to stay safe.
So my phone rings, and there's a custody evaluator on the other end, sometimes one I've talked to before because they've had the same thing happen before. And the custody evaluator says, I got a letter from the board telling me that a complaint's been filed against me, and that this is not an investigation if it's the Board of Psychology. They'll say, this is not a formal investigation, this is an inquiry, which is a lie. It's an investigation.
Inquiry as an inquisition.
It's one of the few white lies that the board's actually telling.
Similar to union wording,
yeah.
actually. Yes, yeah.
And I need some help. And I'm furious because the person who filed the complaint had signed an agreement when I signed on as the custody evaluator that they wouldn't file a complaint against me with my board unless they had come to me first or unless they went to the court first for some relief. And whenever I hear those, I think, you really thought that would matter? And it doesn't even matter to the court, to tell you the truth. What the court isn't going to say, I'm going to put custody in mom if dad did this bad thing. It has no power. The most powerful story I can tell you about how powerless it is about a woman who I represented in Alameda County who was very sophisticated in dealing with family court matters. She had been a special master. She had been a custody evaluator. She had been a therapist of children involved in these matters, and so on. She called me and she said that she was having trouble with the dad of two kids she was seeing in therapy, and that the dad was operating in pro per. He had represented himself, and that he was really out there. She was seeing these kids, and she had given an agreement to both parents to sign that said, if we get legal, we promise that we will not subpoena you or your records because we want to protect the children's therapy. And here, Dad had subpoenaed the children's records and, in fact, sent her a subpoena to appear for a deposition. And so I went with her and we met with the judge in chambers, and I showed him these two signed agreements, and he says, these are contracts and I'm going to enforce them. And so we went out into the court and they called her and he enforced the contract. We went home. 3 months later, they'd spent every cent that they had on lawyers, and they pulled the kids out of therapy because they didn't have enough money to support the therapy. And so Dad subpoenaed her again And his argument was that now that there is no therapy going on, he can subpoena her. And I made these elegant arguments, beginning with this sort of fancy legal one called res judicata, means you already decided this, Your Honor, and about how confidentiality wasn't defined by the legislature as something that ended when therapy ends. Otherwise, my therapy clients, my therapy colleagues would be delighted because they'd never lose any patients. Nobody would want their confidentiality alone, and things like that. You know, confidentiality doesn't even end when the patient's life ends. So, and what kind of a message is it to send children that as long as your parents are willing to pay for therapy, your confidentiality is safe, and when they don't want to pay anymore, they can find out everything that happened. So I made all these elegant arguments, and the judge listened to all of them and then turned to minors' counsel and said, minors' counsel, do you waive or assert privilege? Because the minors' counsel holds privilege for the children. And the minors' counsel just said, I waive it. And because minors' counsel waived privilege, the judge said, okay, you're going to testify. You're going to be deposed by Dad, but he's going to have to do it here in my court, in front of me. And what clearly was going on was everybody knew Dad was a bad guy, and they also knew that Dad would savage this woman when he was going to depose her. And the court wanted to protect her from being savaged, and so they did it that way. But these agreements may or may not matter, so it's not something that I think you can rely on. You can have them, but I wouldn't put a lot of faith in them. So then they send me the letter and the releases that the board sent, and so I can see if the releases are proper, because sometimes there's nothing we can do to respond until we get proper releases. And if we don't get proper releases, I will then contact the board and let them know that we need proper releases. And
From whom?
From whoever the complainant is, and if it's a custody kind of case, you need it from both sides. If you're going to say anything about children in the response, you need a release from both parents, whoever's got custody. There's all kinds of intricate releases that need to, and if they want a copy of the report, sometimes they want a copy of the report, those are protected. There are some situations where someone will demand a copy of a report, and there will be a rule of court that says you can't get one without getting a judge to issue an order for one. So it gets very, very complicated in terms of releases and copies of documents. And then comes the hard part. It's the part that you write, this client of mine will have to write an answer. And I want them to write it and send it to me, because there is great risk in how one answers a board complaint. A board complaint is not a trivial matter. It's not a matter of your business as much as it is your soul. People who have licensing board problems are really in bad shape for a long time. Life becomes very difficult. So the first response is really important, and crafting that letter is really important. And I'll give you one important rule to keep in mind about this important letter, and that is don't trash the complainant. There's a tendency on the part of those of us who get complaints against us to write nasty things, sometimes in diagnostic language. This is a narcissistic borderline who's taking her all out on me. That's not going to help. Even if that was a narcissistic borderline, that's no reason why you shouldn't have done a good job. And they deserve good quality care and services. So don't trash the complainant. Let me trash the complainant. That's my job. I can make snide comments and get away with it, but not you. So I advise my clients not to trash the complainant. And so they send me the letter, and we work on it and craft it, and then I write a cover letter in which I make sort of an analysis of what I think is going on, and then we send it. And only twice I've been practicing law now since 1997, only twice have I sent in letters that didn't end the process right then and there. Two of them went one step further. We had an interview with an investigator who wanted to ask questions. And the interviews resulted in the termination of those processes for my clients. So until today, I didn't know the data on how many people who get complained about actually have actions taken against them, have discipline, because in the years that I've represented people, none of them have had actions taken against them. It's maybe sampling bias that I get people who are in good shape, It may be that I'm a brilliant lawyer. It may be I'm lucky or they're lucky. Who knows? But I never knew that anyone ever got disciplined, or how many. But this is very good news, and it's very good news about the quality of the boards and the board staff, and the experts that are doing the reviews. Gives me what I said downstairs when we met this morning to talk about this stuff was, I'm really proud of the boards. I am the loyal opposition. The deck is stacked incredibly strongly against you. And the reason is that administrative licensing boards are created in the law with a unique kind of power. These are created to protect the public. And because they are charged with the protection of the public, they have license to hurt the people that they govern, that they regulate, badly, and take unfair advantage of them. There are no rules that protect you in terms of being able to subpoena witnesses. There's no depositions. You can't find out what people are going to say about you. You can't get evidence not admitted. You can't. Everything about you can come in. There's no rules of evidence that can protect you from evidence coming in against you. The agencies have an enormous amount of power, and even if a judge finds in your favor, the judge's opinion is not a decision. It is a recommended decision. The board then has a right to not adopt the board's decision, the ALJ's decision. And so going forward with litigation in the administrative arena is a very, very dicey proposition, and one is usually best advised to try and find a way to settle with the board and make some agreement where they have a probationary period, or in worst case scenarios that they surrender their license. And then of course you get your 15 minutes of intergalactic fame because the California therapist will come out and your name will be in it, and all this kind of thing. And it will follow you. But there is life after that. It just comes very slowly and is very, very painful. And the last thing, where am I? I'm about out of time. So let me say the last thing. We had mentioned back and forth a little bit about special masters. If any of you are courageous or masochistic or crazy enough to do special mastering, if your orders, even if your orders give you the right, in fact, require you to make findings and to write orders, to make orders, the judiciary has not protected you from the consequences of having somebody file a board complaint against you. Special masters were not expressly written into the law in any way that says you can't go after these people in civil courts. You can't go after these people in their administrative areas. You can't go after them with their licensing boards. The judiciary hasn't protected special masters at all. And special masters deal with the most high conflict cases that there are. And the odds are that there will be complaints about special masters, and you are subject to board discipline. And the last thing I'll say, which is the scariest of all things, is that there is a doctrine called the substantial relationship test. If you get a DUI, you'll get a letter from your licensing board that says, what's up with your drinking? And because alcohol involvement or chemical abuse is substantially related to your conduct as a profession. If you are found to be in violation of the standards of your profession, even when not acting as a professional, the substantial relationship test can be used to assault your license. And I have in writing from a Deputy Attorney General that even if a judge, in the duties that a judge is performing as a judge, were to also be licensed as a marriage and family therapist or a psychologist or a social worker, and would violate during the court activities the standards of that profession, the licensing board can come after the judge's license. Not as a judge, but as a mental health professional. That no one is immune from that kind of activity in any sphere of their life once they are a licensed person. With the privilege of having a license comes certain rights that you give up and certain protections that you don't have. So that's the warning. How often does that happen? Very rarely. But that doesn't mean you shouldn't be vigilant. You should pay attention. And do everything that everyone says. All the things that were recommended about take care of this, take care of that. And Judge Schneider said, Judge Schneider's very wise. He recused himself from my own divorce case in the 1990s. I remember that. But all of the things that everybody said, do those things, be transparent, dot your I's and cross your T's. I get about 12 to 15 calls a year, maybe 30 calls a year some years. Any of the people that advertise in your journals that are attorneys know this area of law, not just me. Call somebody. Don't do this alone. Don't go it alone. Your answers to the boards are very, very critical. So get somebody to work with you.
I also want to remind everybody that and I said this the other day, your professional organization, if it's CAMFT, if it's AAMFT, if it's California Psychological Association, if it's NASW, you can call them and get a first level of legal advice from their staff, okay, that they have attorneys available who will advise you at that first level. Any general responses that people want to make after all the presentations, or shall we have at it from the group?
Just one thing that I heard, that written complaints versus oral complaints, or a written complaint, requiring written complaint should always be done to the extent that anybody has any authority to do that. It's a weeding device. It weeds out a lot of people who are in an immediate sense of outrage but aren't going to follow through. So when I was supervising judge and people wanted to complain about a judicial officer, they would often come into my courtroom department too and say, I want to talk to you about Judge so-and-so or Commissioner blah, blah. And I would say, great, we can only take complaints in writing, though, and then those people would go away.
Okay. Questions, and it's open about parenting coordinators, special masters, whatever AFCC is dealing with, you got the experts here. Yes?
I got an email last night from a colleague forwarding 2 postings on Yelp about a fellow.
Sure, let me get.
Okay. Yeah, and I guess this is specifically for Steve Frankel. I got a email forwarded to me last night regarding 2 comments which had been posted on Yelp. You're probably familiar. It's a community service where customers are allowed to evaluate community services. And this was 2 postings regarding a fellow custody evaluator in another jurisdiction. Quite unfavorable. This is an internet posting where anyone can evaluate any community service. And these were 2 separate postings regarding a child custody evaluator in a different jurisdiction, but somebody that this was a member of my peer consultation group had forwarded. This evaluator is somebody that we both know, but this is open to the community. Anyone can evaluate restaurants, hair salons, etc. Is there any, and I'm sure this is going to become more popular, where a disgruntled litigant could post a community evaluation on the internet about any of us. Do we have any recourse about this sort of, I guess it would be, libel or slander? Or
yeah. It would be defamation, which is like libel or slander. And then there are 2 separate bodies of law that are relevant. One is the law of defamation, and one is internet law. I'm not an expert in either of those, to tell you the truth. But what I can tell you is that people have tried to get information like that taken off of websites. Very often their efforts fail. And I try to tell people to remember the wisdom of Lee Marvin at the end of his divorce case, which was, I don't care what you say about me as long as you spell the name right.
And I'd point out that there was just a case last year with in a divorce case, a deputy sheriff, and the wife was complaining to his supervisors and putting things on the internet, and he filed and got an injunction against her, which was granted by the trial court and then reversed by the Court of Appeal, who pointed out that you can't have a prior restraint of speech, and that only after you file the slander or libel lawsuit, get a judgment, and find a court finding that speech is libelous or slanderous, can you then restrain it in the future. So basically there's not much that can be done.
And that is reputation. Why don't you come up and use the mic because they're recording this.
If something is ever out there on PDF and it's a Google search, it's really not going to go away. It's found or it's accessed somewhere through something. I had someone who passed away, and I was called because people were going to come from all over to her funeral. Well, when they brought up her name in Google, the first thing they got were all her disciplinary documents. And a very concerned family member called and said, "Can you get this off?" It took me about 8 months and talks with Google to actually do this because it was the lack of relevance after so long time. But once it's like the kids with the cell phones and everything else. If something is out there, regardless of whether it's fair or otherwise, removing it is very, very difficult, even with people who are your advocates.
I just want to return to the question that was already asked earlier about if an individual is unhappy with an evaluator and they call and ask to meet with you about their concerns, and the question about whether or not it's appropriate to meet with them, whether or not to accept a complaint in writing. What's the appropriate procedure for an evaluator?
I'd like to take a first shot at that, although I'm going to ask Steve about his divorce later on. I'm just we have a little bit of time. I'll take the long way around. I went to a bat mitzvah, and I'm at the reception. I sit down at a table with my wife, and the woman at the table looks across at my wife and says, "Aren't you Cantor Anchor? And didn't you do the Jones marriage?" And she says, "Yes, I did." And the woman thinks for a minute and then says, "And isn't your husband a judge?" Immediately, I put my head down. And she said, "Well, yes, he is." And then she looks at me and says, "Aren't you Judge Snyder?" And yes, I am. I knew what was coming next. And she says, "Well, you did my divorce, and you made a big mistake." And I had to make that choice. I decided to let her talk to me, and she had a very legitimate complaint. Her husband, I knew her husband was lying about his income, but she really just didn't have enough information for me to make an order on that. And it was sort of helpful to me to get that feedback from her. And feedback is something we rarely get as judicial officers, and I would say it's probably a little tough for you to get it as an evaluator. But all life is choice. I don't want to be too Sartrean here, but all life is choice. You have to make choices. So if you get that feedback and you sit down with that person, I don't think that there's anything wrong with that, except you are never going to be able to touch that case again. And you might be coming back, and maybe you want to, maybe you don't want to. I didn't particularly want to handle that woman's case again, so if it came back to court, I would have recused myself. So I didn't mind, but you have to make a choice there. I think you can talk to people to get feedback later. I think there's a lot of value in that, even from crazy people. You can hear things that is worthwhile, but you have to recognize that you are then out of things, and that someone may be playing you. They may be they know that there's going to be an evaluation 3 months from now, and they may be coming to you to make sure that they muddy the waters and you can't do it. So it's a choice you have to make.
But if the matter isn't yet closed and it's scheduled for trial, and they call you and they want to talk to you about what they don't like about the way you handle it.
Yes. If they this is now before trial and before you've made your report.
Or even the report is out, but the judge there hasn't been a ruling.
Okay. You should not talk to them at that point, but if you want to, there's nothing wrong with a feedback session. If they're either self-represented or if they have a lawyer, tell them to call their lawyer. Tell them if they want to have a feedback session, if everyone agrees, and I'd get it in writing, if everyone agrees in writing, you would be happy to sit down with both of them, give them a feedback session, tell them where you are. Many evaluators, before they write their report, do a feedback session first. There's nothing wrong with that, but you cannot do it one side only. That is a violation. They aren't allowed to talk to you. There's this, I don't remember the statute, maybe somebody else does, 213, 216 of the Family Code. In any case, that is inappropriate to talk to them solely, but not inappropriate if everybody has a notice and agrees to, and you talk to the whole group.
Steve?
I would agree with everything that Judge Schneider said. And I'd add one other thought, and that is that there are empirical data, supporting the proposition that saying that you regret something, if you did something that you regret, reduces the likelihood of litigation against you. There's actually a statute in California and 21 other states that's called the Apology Statute that protects your words as long as there are not specific admissions of liability from being used against you in a civil matter. and it's based on data. So being able to meet with people and hear what they say, we know this as clinicians, but being able to meet with them and do it properly, structured in a proper way, actually can often reduce some of the heat.
Question? Yes, come up to the mic. See, it's going to take so long. People are going to think we're in a huge hall and there are 800 people.
I'm wondering if a person is licensed but is an employee of the Superior Court, although they're licensed as a psychologist or MFT or LCSW, does that make any difference when a complaint comes before the board?
Nods of the, as I've been told in court, nods of the head don't count as testimony. You need to use words.
Not to us.
Right? The Board of Psychology and the Board of Behavioral Sciences says that that's not an issue, meaning that it will be investigated like every other licensed person. Okay. I guess the difference, though, is, Lily, we talked about it earlier, is that if you're working for Family Court Services, then they serve, might be a bad word to use, but they serve like your insurance. They will stand with you and
They will, our counsel will represent you. And that actually is something that we just arrived at this last year. So before that, you were on your own. But it was because of an internet posting case that we realized how vulnerable our staff is, and our court's counsel agreed to represent our staff.
So they're not insulated, they just have representation.
Correct.
But we don't know that that's true in every county and every family court service, do we?
No.
No. Okay, so that's an important thing.
Two questions for Mr. Frankel. One is on the dual license. Should a complaint be filed against an MFT and they hold an RN license, can they go after that?
My understanding is that if there's an administrative action, actually I should defer to you guys.
I believe it would be related.
Yes. And it depends on the nature of the individual. To a certain degree, it may depend on the individual practice act. What we will do when we're aware that an individual has a license with another agency is we will notify the agency of the action. Commonly, BOP and BBS have people with dual licensure, so we will coordinate our efforts on a disciplinary matter. So what you can be confident in is that all the agencies will be aware of the action, whether they choose to or whether they have the statutory authority to pursue a disciplinary action based on the other license is going to depend on the other license. Does that make sense?
Second question, Mr. Frankel. You raised my anxiety level about special master. So
Good.
Could you clarify? You raised my anxiety level in two areas today, RN as well as special master. But would you talk a little bit more about what you're referencing? If you're crazy enough to be a special master, or foolish enough.
What I'm referencing is that people who judges appoint special masters to deal with are among the most high conflict cases that there are in a world of high conflict already, because they couldn't work with mediators. So special masters are buffers for judges. They protect the judges from having to deal with this craziness all the time. But they're mediators with teeth. They actually can write orders if their orders say that. They can make orders, make findings, and so they're acting in ways that actually directly influence someone's life in ways that mediators don't. And as a result of that making orders, they can actually get somebody totally completely enraged against them. The easiest thing for them to do is to deal with that rage, besides launching it directly, is to go to the licensing board. Generally, licensing boards don't find against special masters, but they can cause them all kinds of trouble. Being investigated is not a lot of fun, and the probability of complaints against special masters, I think, is pretty significant.
Here's a footnote about special masters. It seems like that term alone kind of lends itself to attack special master. And the proposal from the AFCC is that parenting coordinator be the universal term used. I know there may be some reason why in California because it got ensconced, but ever since I heard that, I'd always raise my hand at a workshop and say, that didn't sound too good when we're talking about helping families. Special master. maybe it is good from some other civil arena where you talk about a special master for evaluating this or that, but I've never liked that term with regard to families, and I think if we can get away from that term, it would be better.
In Los Angeles, we have carefully drafted a 17-page stipulation for appointment of parenting coordinators. And in that, we say that the parenting coordinator is acting in a quasi-judicial role and should have appropriate immunity. We say it. We don't know exactly what the effect will be. We'd like it to protect them against licensing boards, but we don't really think it's going to happen. It's the shot we can take. And I would encourage people to continue in that role if they want to, although you are putting yourself at risk when you do lots of different things. It is very satisfying work when it's done successfully.
Let me step out on a limb, and the executive officers will tell me if I need to jump or not when I reach the end of this. The issue coming in front of the board, though, is going to be the same as any other licensing issues. It's the same as, it's not about whether or not you did a good report or bad report even, or whether or not you even got to the right conclusion. It has to do with whether or not you stayed within the ethics of the profession. That if you did stuff that you can show you were trained to do, okay, and you had the appropriate training to do that as the field can have it. If you're staying within the boundaries of your license, if you are not having dual relationships, if you are following the rules, okay, then you're going to be okay. It's not easy, but if you are acting professionally, you're going to be okay. If you're having dual relationships, right, and you really need to think about dual relationships, you better be really careful. If you say, I'm a parenting coordinator, and I was the evaluator, you better think twice about it. Okay? That probably not a very good idea if you were seeing somebody individually in therapy, okay? And now you're saying, well, now I'm going to be an unbiased person, even though I have information from over on the side. Remember, the dual relationship is about, is that a relationship that will affect your judgment in dealing with your job with this family? So the rules in front of the board are going to be the same. Paul?
The overwhelming majority of our disciplinary actions are charged out as gross negligence. Gross negligence is defined, loosely speaking, as an extreme departure from the standard of care. What this means is we don't have the authority, generally speaking, unless there are some other specific violations, for which we do have strict liability on those other violations. Ordinary negligence isn't actionable by the board. That we have to find, and actually the disciplinary process, while I do appreciate it has a significant consequence on the people who are subject to it, we have a very high burden to cross. Broadly speaking, we have to find that you were grossly negligent, which is an extreme departure from the standard of care, not an ordinary departure. A single act of simple negligence doesn't get you over there, doesn't get you over the bar. And we have to prove it by clear and convincing evidence, which means our case is you really messed up bad and in a way that no reasonable thinking therapist could get to, even just doing ordinary dumb stuff. And that we can prove it by clear and convincing evidence. And the overwhelming majority of the activities that we engage in boil down to contests of credibility between the complainants and the respondents. There's always a certain amount of documentation. Some things we get the paper on. We love those cases. Those are easy. You said you did this. Everybody agrees. Yeah, that's an extreme departure. Boom, we're done. That's very simple. Most of the time, it's going to turn into a contest of credibility. By definition, frequently, a lot of our complainants aren't the most credible people. They don't necessarily stand up well to cross-examination. These are on matters that are of enormous sensitivity to them, things they may not well be comfortable speaking about in a hearing full of legal-looking people. The consequences are real and serious and consequential, but the board does have significant burdens to meet in getting any disciplinary action through a process. So I wanted to highlight that because Ian's talking about, if you're doing good practice, you got nothing to worry about. Yeah, you really do. Because kind of an ordinary, anybody could have done that mistake isn't going to get you disciplined by the board unless it's in a couple of very particular categories. In terms of general practice, once again, it's that extreme departure. It's that gross negligence. And we see a lot of complaints that are ordinary negligence that we don't act on. So just understand that there's a spectrum of conduct, and in the feedback I consistently get from board members, and they get there and they get their first mail ballots, and I can tell you it'll happen. I know exactly when the mail ballot goes out because whoever the new board member is calls me, and I can't talk to them about particulars of the cases because we have separation of authorities issues, but they do call me and say, oh my God, I didn't know people did this. The cases they get, broadly speaking, are so far beyond the pale, they're not line calls. And that's pretty consistent across the board. Like I said, there's some particular categories where you do have a different exposure, but most of what we do is gross negligence. And like I said, these are not simple mistakes that therapists make. They are huge mistakes that therapists make.
Okay, those things get weight. Consistent and size. Big Bob?
Yeah, similar. I think in our mission of consumer protection, there's an essence of reasonableness to everything we do. What's commonplace, what occurs, what's a normal bit of negligence, what's a bit of forgetting, what's a bit of this. So once again, the bar is very high. We do not attempt or influence or anything to go below the bar and grab those who are more or less on the lower end of all this and bring them up to where we can discipline. But as Paul said, some of the things are just so, I read things and it's like, how can someone actually think this way, regardless of whether this person has a professional license of any type? Our board, my New York came out, I'm sorry. Our board is of the mind to act on complaints about special masters. They still think somewhere in there is the practice of psychology, and the Attorney General's office is also in agreement. So when we get a complaint regarding a special master, we have one case going on now that's been since I was appointed regarding the way that is being viewed, and it is actionable.
Ian, can I add a footnote about what you said about the standards? We have training for new mediators and evaluators that are hired by the court, and we coined this mantra. Usually when it comes to the part of the agenda that said rules of court, people say boring, rules of court, but we say rules are your friends. We kind of sold that to them that it's good to know the standards and to follow those, because if you can write a letter or have the attorney sit down and say, this professional did this and this and this, and this is what the rules of court say, or the standards of the procedure, that's to your benefit. So it's really something to think about. The rules are your friends, and it's important to know what they are and to follow those. And if you can say you did, then that's a big plus, I think.
Just a comment to take more questions, but Steve is right that the board does not have to sign off on the recommendation from the administrative judge. Okay? I can tell you that in 4 years of being on the board, twice we didn't, okay, because we were just so appalled by the situation. When we don't, okay, then the mandate is we get all of the transcripts and all of the evidence, okay, we get a box of everything that happened, and before we meet, we have to review all of that before we sit in this kind of appellate arena and do that. So it's going to be, we're going to really think twice about that, and it's a very serious thing. And actually, in both cases, we did think they were very serious issues. And so we're willing to do that if we think that the administrative judge just kind of, was out to lunch on it. But it's very rare.
For BBS, I don't know what it's for the Board of Psych, 70% of our cases are settled. We do not go to hearing. And 70 to 80%.
What you mentioned before about it comes down to credibility of the complainant and the credibility of the therapist. Would you comment a little bit on the type of documentation you want to see from the therapist. Any and all. And it goes back to what our work product is and how we maintain our records and what kind of notes we keep and what kind of treatment records we keep and doing all of that.
We will ask.
What is it you look for in that?
We will ask for what we need for that particular case. I'll tell you, in looking at the material, the people who come out of the process looking good are the people who have records. I'm serious about that. That are more than scrawled notes on a pad somewhere.
Right, 3 posties and you're off. Yeah.
And keep in mind, I mean, all of our judgments about what we proceed about are informed by a review by a licensed expert. So we will gather all the information we've got. We say we think there's something here. We're going to send it off to the expert, and the expert's going to write a formal opinion for us back about the whys and wherefores of this. I'm not a licensee. I don't possess the art. I don't pretend to. But what we look for is there a thought process? Okay, I have a dual relationship. It's here. Did I get consultation about it? Do I have an articulated reason why this is still okay and how I'm going to guard against potential negative things? That goes a long way. I'm not going to say it's going to get you off the hook for something, but a process where the therapist demonstrates they're aware of the issues and are working to deal with the issues, and particularly aware of the issues and how they impact the client. We're a public protection agency. Covering your own rear end, I'm happy if you do it, but at the end of the day, we're here about the client. Those things go a long way. I mean, I've seen some cases from therapists who had beautiful documentation on what they did, and it's a he said, she said. I'll tell you, if it's what someone says happened, and you've got documentation about this is what happened, that's a whole different debate. So you advantage yourself by documenting the thought process and the things you went through and what you did, because then it's very hard to say the greatest case of extreme negligence is not thinking about it.
So what I tell people when they ask me, they call me and they say, I'm a therapist or I'm involved in a custody evaluation and they're making an allegation of child abuse, but I don't think it reached reasonable suspicion at my knowledge, especially in the context of the case and so on. Do I have to report? And I'll take counsel on it as well, that I would say if you believe after you got the report that it didn't reach reasonable suspicion, you better include in your notes why not. Right? You want to?
No, it's right. One more thing on the issue of your response and anything that's needed by the board. This isn't a way to get around it. There has to be some realization or contrition towards the harm to the public or the harm to the consumer, or you understand why these things are a certain way. On a lot of my informal conferences, why the fine should be reduced and everything is like, I'm old and I have no money. But that is not a reason for a consumer protection agency to even look at that. It's like, well, have you learned anything? Is this cumulative? And there are certain sections where if certain conditions are met, the fines can be increased, and this is just going through the process. So I think you almost have to take yourself to a third-party perspective and say, okay, if I was looking at this, how would it read? How would it be? And realize that the boards are not here. Many people think that the Board of Psychology is the California Psychological Association. No, we're not advocates for the profession. We're not meant to get in your way, make it hard to be licensed. We have a certain mission, and with that mission of putting people at what I consider poor wording, a minimal level of confidence to enter the field, has the responsibility that comes with that once you're there has to be purely from the board's issue of consumer protection. And that's the heavy hand that we look at things through. It's not to make your life miserable. It's not to nitpick and do this. We're coming up ways to streamline licensure, regulation, get you out there because you're needed by the public, you're needed in underserved areas. But once again, there has to be a personal responsibility to the consumers of all these mental health services. And if that is understood during times of extreme discourse between the boards and the licensees, I think it works a lot better for you.
My question is on record keeping also, and in the role of a psychotherapist, if I videotape sessions or parts of sessions for the purpose of educating parents about interactions, and my policy is to destroy those at the end of a relatively short term of therapy, is that a problem? Because records in general, I wouldn't destroy printed or computerized records.
There's no hard and fast state law about retaining records. And so I can't say at this point it's okay and at that point it's not from a time standpoint. And I wish I could be more straightforward than that.
But the guidelines for case notes are quite a bit longer than that. 10 years and...
Those are guidelines that are out in the community. They are not statutory saying you've got to keep things for 10 years. There are, and once again, if we're looking at something around a negligence issue, well, did you destroy them the next day? Did you keep them until the end of therapy? We're going to give that to an expert. An expert's going to say the standard in the community is this. Broadly speaking, they complied with the standard, or no, it's not even in the neighborhood. And that's the analysis we'll go through. And others may have.
Lily?
One other question. In our court, we ask our staff to keep really good notes, and we use that in the process of the work. They point out to me, though, that there's a neighboring county where they actually destroy all the records after they have seen the parties. What do you have any comments on that? And I know that one of our attorneys actually, in teaching us, this was several years ago, not now, but this attorney, it was from the county counsel's office, advised us not to keep very many records because that way they couldn't be used against us when they were, when they asked to be copied.
That's right. If you keep 3 years of your email during a legal process, they'll go back and they'll get everything you have there. If you only have 6 months worth of email, well, they're only going to be able to go back 6 months. So to protect yourself, do you keep your taxes 7 years? Or you personally had issues where you keep them 11 or 12, or you're destroying them every other year? That's the standard of safety you have to bring on yourself.
And I wouldn't use as a personal guideline what a county is doing in family court services. That if you work in that family court services, you might want to talk about it with the people there. But on a personal basis, you're going to be held accountable based on the standards of the profession. They're going to look at the ethics codes of your various organizations and of the organizations that relate to that as guidelines to do that.
For MFTs and LCSWs, there's a very direct statutory requirement you maintain records that are sound clinical records. It's not a specific this long for this kind of record and this long for that kind of record. So it is going to tie back to what practice is. What I will tell you anecdotally, we get complaints about a lot of folks, about a lot of things. A lot of therapists don't have any records because they think that makes them safe, and that immediately invites them for a charge of failing to keep sound records. So you need to use your judgment. You need to talk about what's going on out there in the community. What are your peers doing? What are good practices? Those are the sorts of things that are going to be referred to if we go there. But I will tell you, in what we see, I've not seen a case where someone had a record that doomed them. I've seen a lot of cases where they didn't have records and it did. And I can tell you a lot of cases where they had records and it saved them. And you need to think that through, because like I said, at the end of the day, if all there is he said, she said, you're in a credibility fight. Do you want anything besides credibility? You need to think that sort of thing through. So from my standpoint, I see a lot more risk in not having records than in having them.
Let me just say quickly. I think, from my perspective as defense counsel, your records are your way of telling your side of the story. And it's very important that you be able to tell your side of the story. My inclination generally is to keep records forever. But my recommendation to clients when they call me is that they keep them for the length of time that they're exposed to some sort of action against them. And the longest period of exposure that we have is 10 years after we've just seen an adult. And when minors that we've seen, if we see minors, when they turn 28. Because that's the length of time that a licensing board can take action against us when there are allegations of sexual improprieties. 10 years from the last time you've seen an adult, 10 years from when a minor turns 18 and they turn 28. So if you keep them for 10 years after you've seen adults, or 10 years after minors turn 18, you can tell your side of the story in the event that you need to. And that's what you need to do.
Wow. I just thought of this. So on custody evaluations, I don't just have to keep them for 10 years. I got to keep them until the youngest child is 28 years old?
I would say that for custody evaluations, you keep them forever.
Okay.
That's when I do something that's involved in the legal proceedings. I keep those things forever. You can never tell what's going to happen and whether a judge is going to want to see them. I tend to keep them forever.
Is it just as good if I convert it to a disk and copy it on?
Sure. That's fine.
Okay. Anything else? Yes.
I have a practice will. What would be the advice I should leave on that for my heirs? I have colleagues that basically have offered to wrap up my practice in the event of my death.
Okay. That's an ethical requirement of everyone, is to have plans in place already for dealing with the administrative aspects of your practice in the event that you are not capable or willing to continue. And there are lots of different ways to do that. You can Google some professional wills. There's a great variety of different forms. What I think is really helpful is putting in your informed consent right from the beginning. In the event that I don't show up for a session, or that you can't reach me, call so-and-so at such and such, and your signature here acknowledges that you understand this and that you agree that so-and-so is going to have your charts if I'm not able. And then, so you tell them who to call, what to do, how to handle it if you're not available.
Well, no, actually my question was about, in terms of my professional heirs, how long should, and what should be the arrangements for keeping my records? I mean, should they be kept into the 22nd century?
No, they should be kept as long as your estate is exposed, and that turns out to be the statute of limitations on a civil suit. Because once you're deceased, you're out of, shall we say, out of the board's jurisdiction.
No, they're not. My goodness.
There's no actionable. They can't come after your license once you're deceased. But your estate is still vulnerable to a civil suit after your demise for a length of time that's approximately 3 years. It's a year from discovery, or 3 years from whenever the bad thing took place. So records should be kept for 3 years from the last time you saw the person whose chart it is, and that's how long they should be kept by your heirs.
So basically 3 years after my death.
3 years.
Any other questions? Okay. I want to thank everybody on the panel. This was wonderfully informative for me. I hope it was for everybody here. And